Does your clients recognize that there was a $40,000 down payment made?
Darren's mother made a payment, which has been returned, and there's a receipt provided.
Has that money been returned?
No, Your Honor. I don't know that my clients have gotten that.
If there was no deal, why do they accept these payments?
Big picture here, Your Honor, the reason that we asked for such a quick setting is because ultimately they are seeking the eviction of Aaron Budarakis from the premises. The best that I can describe what is happening here is that the defendants in this case, both through the LLC and personally, are essentially trying to use an eviction shortcut over a disputed ownership property situation, which I think Kansas law very specifically addresses. And that's why we're here, Your Honor, is to stay those particular proceedings as it relates to the eviction until those underlying property rights can be determined under our initial petition in this case. We believe and would submit to the court that defendants are misusing the eviction process. Defendants' initial argument in response to our motion was that because no executed contract exists, that is a mouthful, that we're not under the Contract for Deed Act. First, Your Honor, I believe the defendant's argument is contradicted entirely by the March 2025 contract for purchase and sale of real estate. It was executed by both defendants. That is an agreement to sell the property. That agreement expressly on its face contemplates seller financing with an interest rate in over 28 years, payment terms, confirming that the parties did initially agree to a seller finance structure. An owner-carrier arrangement necessarily involves payment over time. And this contract on its face that was executed by all the parties otherwise indicates that that was always the plan. In this case, my clients paid $40,000 in cash to the defendants in this case. They haven't accounted for that $40,000. They didn't offer to return the $40,000 during the eviction proceedings. But I don't understand there to be a dispute that the $40,000 was received. Beyond that, there's no dispute between the parties that the plaintiffs had made ongoing monthly payments. Again, the mere existence of a catch-up and transfer agreement presupposes that an ongoing payment obligation was tied to ownership, not rent. Those payments have been accepted as recently as, I believe, April 1st. No, I don't understand, or maybe in March. Maybe the last payment was made in March. I see Mr. Alvin shaking his head, and I don't want to misspeak, but I know the March payment was made. The Contract for Deed Act governs the rights at issues here. It states that a buyer's rights under a contract for deed shall not be forfeited or canceled except as provided in the section. That statute is designed to protect a buyer's rights in this exact scenario, that their equitable interest cannot be forfeited or canceled except as provided under the statute. Defendants further allege that Aaron Budarakis, who is in possession of the home and is living in the home, doesn't have standing to participate or any enforceable interest in this case. Here, both defendants were aware that Aaron was residing at the property. Both defendants accepted payments while Aaron was residing at the property. And both defendants were put on notice by Darren Budarakis, who is a buyer to the contract, that he intended to assign his rights, any rights that existed in this property, to Aaron. That has been made abundantly clear. There are written text messages between the parties that evidence this.
Very well, Ms. Linskog. Mr. Alvin, I noticed that during Ms. Linskog's presentation before the court, you were smiling quite a bit. I don't know if you were particularly entertained, but this court doesn't see anything funny or entertaining about the situation currently before the court. But I do trust that you have some sort of serious response that you wish to give the court. Is that true?
That's correct, Your Honor. Your Honor, the plaintiffs are asking for an extraordinary relief based on a theory that does not match the facts or Kansas law. There's no executed contract for deed. There's no substantial...
Let me just interrupt, Mr. Alvin. If we don't have a contract for deed situation here, what do your clients think is in place?
We have a failed real estate transaction. If you look at the exhibits that were produced as part of this petition, there's a purchase for sale contract, a contract amendment, financing terms, and a catch-up transfer agreement where there's only one page without any signature. We don't have any receipts for payments. We don't have any payment structure. We don't have any of those things that even under a normal contract for deed or even any other type of foreclosure defense that we would actually see where we would bring up, well, these are the substantial performance. I think that we've lost sight in that argument of what the basis of this is. It's a preliminary injunction, which before anything can be done has to presuppose the likelihood of success on its merits. We have no binding contract where there's multiple drafts that deal with negotiations. The contract law states specifically that that is not a binding contract and you can't be bound by those negotiations. That is the King versus Winger case. We have a divorce proceedings, which 2707 doesn't just talk about it, but it allows and does not allow unilateral transfer of property rights without court approval during a divorce settlement.
Does your clients recognize that there was a $40,000 down payment made?
They recognize that Darren's mother made a payment, which has been returned, and there's a receipt provided.
Okay. Has that money been returned?
Yes.
Okay. Ms. Lenskog, do you acknowledge that point?
No, Your Honor. I was unaware of any return or receipt. Mr. Albin hasn't provided any of that to me, and I don't know that my clients have gotten that. The $40,000 was paid on behalf of Darren and Dawn through the sale of another home that they own directly to Costa Budarakis. My most recent conversations with both of those individuals has indicated that the $40,000 was paid in cash. They don't know where or why it hasn't otherwise been applied. In conversations
are
with
you literally talking about currency that was provided?
cash. Mm-hmm.
Okay.
Well, I'll get to my other question later, but no, I don't know anything about the return of a $40,000 payment.
Okay. Because you've asserted that, as one of your points, that that the sellers in this case have accepted a $40,000 down payment.
Yes, Your Honor. In March of 2025, the purchase price was reduced by $40,000 as $40,000 was paid in cash. By
my understanding, there was an agreement that there would be $1,850 a month paid. Correct?
That's correct, Your Honor. There's considerable history here where these payments have been made up and into current, or have been made current. There is no default under the existing contract. One of the questions that I have is sort of how we get around the real estate purchase agreement that it says it's an owner carry, which means a seller financed. It's an owner carry. Line 35 says it's owner carry. So the owner's carrying the financing at a defined term of 28 years at a 4.765 interest rate. Payments have been made under that owner carry for this entire year while my clients have been in possession of the real estate. I'm not sure how we get to this is a failed real estate transaction. Sorry, Your Honor.
Ms. Lenskog, you've made an assertion to the court that at this moment I'm going to take it at face value, which begs the question, Mr. Albin, if there was no deal, why were a series of payments accepted by at least some of the defendants or perhaps all of the defendants at different times? Why do they accept these payments?
From my understanding, Your Honor, and it's that it acted more as an option contract to keep the contract alive until a closing could happen.
Under that theory, Your Honor, my clients would still have the right to close under the contract for deed since all payments are current, and the terms would be continuing and evicting Mr. Aaron Budarakis, who is there by consent of the buyers of the real estate, would effectively negate even under Mr. Albin's version of events, would negate that ability and that right to do so.
Mr. Albin, your response to that?
Your Honor, if that's the position of the plaintiffs at this point in time, when I file my answer in this, I'll just ask for a specific performance and we'll sell the house and be done with it. If she believes that they still have an option open and that they are working towards a closing and a resolution of the contract, then we would allow the court, or would ask the court, to set a specific date for specific performance to happen.
Are you talking about doing a formal closing with them obtaining third-party financing, having a mortgage through the third-party financer, and essentially getting your clients out of it?
Absolutely, Your Honor.
Right. Ms. Lenskog, your response to what appears to be one possible way this matter could end?
Yes, Your Honor, in that exact scenario was proposed to the defendants prior to the eviction hearing, and they declined to engage with me whatsoever on that particular issue. I had to go and argue where my clients were called squatters and otherwise sort of said they have no rights and they need to get out of here. I asked that the case be stayed. They refused to stay the case. I had to seek injunctive relief. I had to file an action here. My clients had to pay for all of that. And while I understand Mr. Albin's perspective, oh, well, legal fees are a cost of doing business. Well, unfortunately for his clients in the Contract for Deed Act, legal fees in this case are not a cost of doing business. They're a penalty for violating the Contract for Deed Act in the first place. So,
very well. The court will decide the matter, which is currently before it. The court does find that each tract of real estate is by its nature unique. When a potential buyer, like we have in this case, is deprived of an interest, and interest could extend to, as far as in Aaron's case, an occupancy interest, that it merits protection. The court finds that the plaintiffs have shown that they have a substantial likelihood of proceeding and winning on the merits, that there is no adequate remedy at law that would substitute for the injunctive relief which is being sought, and that they would suffer irreparable harm if they were evicted from the premises prematurely until this matter was sorted out. This court will grant the motion for a preliminary injunction in this case to the extent that it places a stay on further prosecution of 2026 LM 427 in the Butler County District Court. The court obviously will not dismiss that. And the court certainly understands Mr. Albin's position that, if anything, that proceeding is stayed and not dismissed. I encourage the parties to kind of build on the foundation that was laid late in today's proceeding about there is a way perhaps in which the contract can be finalized by third-party financing and more traditional handling of a real estate sales. Regardless of who the buyer might be, I think under the contract it would be Darren and Dawn. And obviously there's going to need to be some cooperation between the two of them. The court will preserve the occupancy rights of Aaron Budarakis and his family at this time, as it doesn't appear that Darren or Dawn are challenging their current occupancy. All right, Ms. Lenskog, with the injunction granted, was there other relief sought under your request for injunctive relief, which the court has not yet addressed?
Your Honor, the only open item as it relates to our motion for injunctive relief is just clarity as it relates to the ongoing payments under the contract for deed. My clients are happy to pay them into escrow. Whatever the court's order is there, I just think we need clarity on how moving forward and whom they should be paid to.
I will address that. Now, when is the next payment due?
May 1st, I believe.
All right. The court will not require a bond in this case. Rather, security is insured by this court will require the plaintiffs in this case to make the $1,850 per month payments to Ms. Lenskog's client trust account, with her to hold those payments until further order of the court. That way, with those payments being made systematically as these proceedings continue, the money is there to be turned over to the proper party if deemed to be appropriate by the court later. The court has no intention of granting any request for relief to stop payments.